So we continue the conference on Justice against GBV, which is victim-centered. Now it's time to prepare for the next discussion, and I would like to invite here speakers to this new next conversation. The moderator will be Pavlo Parkhomenko, please welcome, and other speakers, Vasyl Bohdan, Oksana Dymytriieva, Oleksandr Banchuk, Olga Kalashnik, Vera Levko, and Zaman Ali Hassan. Please. Dear colleagues, Olena Tkachuk, we found your mobile phone. Please approach me. I'm going to return it to you. So, of course, it's not that easy to break immediately after lunch. So this is the first panel discussion regarding identification and investigation of GBV, regarding children, approaches and challenges. It's an hour and a half discussion. In the previous discussion, we said that children have to be in the focus of attention. They should be treated differently than adults. And the problems that emerge when identifying such cases, investigating for further court proceedings, and the child-friendly investigation. And it requires well-trained experts. It requires training, and we can see from the content of this discussion and attendance of this discussion that represents different institutions, which shows the importance of this topic and how important is the public policy to maintain the best interest of the child. And considering this, we will listen to experience of different institutions, different practitioners, and the challenges that they run into, maybe. So we might begin from the representatives of institutions that stay between the criminal offense committed and the protection agency. So the ones who talk to the victim, who are the first to respond and who determine what the next steps will be, identification and investigation, etc. So Vasyl Bohdan, head of the Juvenile Prevention Department, National Police. Vasyl Bohdan, to share the challenges and experiences that we have currently as the Ministry of Internal and Juvenile Prevention uses steps to identify violence. So for up to 10 minutes time for each intervention. Hello, colleagues and friends. Of course, it's a very important topic, and there are a lot of nuances and questions that it's necessary to discuss, and a lot of different areas within this. And just like many of you from different governmental branches, your thinking is also very important in preventing GBV and domestic violence. As we've heard many important things today, especially by my colleagues, by police officers, and from me personally, I would like to add that I fully support their opinion that the National Police is open to cooperation in battling these important challenges that we have, especially battling GBV and domestic violence. So 2 years now, almost all the topics in the media in Ukraine are full of war, and that's not surprising, that is understandable. But you don't have to forget, though, that the types of criminal offenses and violations of human rights that were in peaceful time, they didn't go anywhere. They just went into the second, on the background, in the media maybe, and both domestic violence, especially acts committed against the most vulnerable population, which is children, especially needing protection in the wartime. So first COVID, now then war, staying so much at home, remote learning, constant stress, only increases risks of such acts being committed. And it would seem that child-friendly spaces, what should be a child-friendly space, which is family and home. In due time, Ukraine has implemented all the norms of international law in preventing and countering domestic violence. It ratified Istanbul Convention, and we have now one of the most progressive legislations. So this legislation, what does it give to us? It introduced tools to prevent like temporary restrictive injunction, risk assessment, all these things were introduced and implemented in our law. So awareness raising regarding of our citizens regarding the illegality of domestic violence and GBV. And as a consequence, less concealment of these kind of acts, that it's more on the surface, less latent. So more complaints filed to nation police and other law enforcement. And so this increase means that people file more complaints, not that the acts have been committed more. So the problem is less concealed. As was noted this year, National Police received 240,000 complaints. Among them, 7,700 coming from children regarding such acts committed against them. So this number, 26% bigger than last year and 30% more than in 2021. So also this year we have seen 10,000 children have become victims of domestic violence. Last year it was 3,500, 2021 2,000. So even the children themselves are filing more requests. So that means that mechanisms of prevention do work. But with the war, regardless of the progressive legislation, new challenges emerged. So, meaning acts of violence committed on temporarily occupied territories where the perpetrators, well, the victims have less access to basic services, and such acts been committed more through destabilizing economic effects because of war, long-term psychological tension, and other consequences of the war. And also, the problem of domestic violence has been overlooked by the victims themselves. They think now it's not the time. Who cares about domestic violence if there's missiles flying overhead? Nobody has time for that, and so they are reluctant to go and file complaints. At the same time, the victim might be busy surviving, creating safe environment for themselves, their family, building a new life in a relocation, etc., etc. And they have no time for that, or they think it's not important, and they are reluctant again to go to police the complaint against violence. So, but I would say there's another side to this progressive legislation. We understand what will only work only after certain time of collective evidence, because these norms were very new. We had no prior experience of applying them. And that's why right now we analyze the experience of using these norms and designing norms, and in particular protecting the rights of children witnesses. And that's why it's important to talk about problem identifying the fact of child witness. And not in all cases such witness children provided assistance and even instruction what should be done, how to identify children witnesses, how to work with them. At the same time, the very institution of witness victim has emerged for the first time, and only first been recognized around only one criminal offense. At the same time, there's a problem of applying these laws. In some cases, Domestic Violence Prevention, Criminal Code of Ukraine, the Code of Administrative Legislation, as for the victim and survivor child. So not always the children witnesses are recognized as victims of these crimes. And therefore, they have no recourse to the law to claim protection and social services. Another problem, in my view, is that we need to improve accessibility or availability these basic services and responding to domestic violence in rural areas. And it's a separate scope of problems need to be discussed. So, as was mentioned today, we as a police participated in designing new laws, amending the main laws that regulate responding to domestic violence. In particular, these changes describe recognition of children witnesses who were affected by domestic violence, detecting such fact, and guaranteeing for the victims the basic social services. It's also important, as my practitioners, as colleagues would say, interaction, or proper interaction, to record and register the acts of domestic violence to be later recognized by the court. We have, together with Supreme Court, we've done a roadmap. We've just recently had a coordination meeting, how court decisions should be ruled, and acts of domestic violence were recorded and registered. And so we worked out a certain algorithm for staff of the court and law enforcement, and we don't stop there. We also planned to conduct such coordinational meetings in each region to involve the local communities and grumadas, anyone who's dealing with the battling domestic violence. So results of these meetings were specific algorithms for specific regions, depending on their specifics. So, in particular, the national police also faces certain challenges in terms of training police officers in the sphere of new laws and preventing domestic violence. So we are doing constant trainings, and we're trying to improve the professional skills of police officers whose job is to respond to this. In order to prevent secondary traumatization and repeated offense, to avoid repeated interrogations for 3 or 4 times the same child, especially if it's about the victims of sexual violence, which only creates secondary traumatization. So we organize these so-called green rooms for just one interview with the child. The network Barnahus, my colleague Oleksandr will tell you more about it, how they are being organized. In particular, since the moderator is keeping a sharp eye on the time limit, I see that I'm taking more than I bargained for, but still, it's a very important issue to create safe child-free spaces in cyberspace. So we have units at the Juvenile. It's a draft. It's a project. So prophylactics in the networks. So what children are doing in cyberspace. They're only starting working. These police officials, we're training them how to effectively respond to the challenges we face, because it's a different methodology. We provided some course books, some guidelines for law enforcers, for educational community, how to respond to the challenges that they face, and identifying these threats in cyberspace as well, and many other initiatives. So finally, I would like to note that, of course there are challenges. We don't hide them. There are problems in responding, in documenting, and in no way the national police is hiding behind tall walls. We're open. We are quite open to cooperation. Thank you. Thank you, Vasyl. It's a very informative presentations. The steps that the police is doing, we can see them. Earlier, in my childhood, we parents used to scare us with saying, "Here's police officer." Now we are learning to talk to police officers as our servants, and it's important that children know that police officers are to rescue, not to pursue you if you didn't commit anything. So working with children, training teachers is very important. Next to speak is the person whose job during the pre-court investigation important, and after during the court hearing, and I mean prosecution, who have such a serious burden and amount of work. And thanks to their approaches, thanks to new change of policies, children, now we are child-centric approaches, victim-centric approaches. I'd like to hear General Prosecution Office. The Oksana Dymytriieva is the head of Department of Protecting the Interests of the Children who are part of the criminal proceedings as victims. So tell us about the challenges you face as prosecutor, especially in terms of protecting children against sexual violence, gender-based violence, and when a child is in the judicial system. Happy to greet everyone. Sorry, I've lost my voice. I have to speak, but my voice fails me today. So I'm going to talk about the algorithm of establishing or recognizing children as witnesses of domestic violence, what's their legal status, and how we should protect them. The problem of GBV or domestic violence is not something new for our society. Unfortunately, it was still prominent before the large-scale invasion and remains now and will continue to be so. In the crisis situation, all the negative phenomena are coming to the surface. Sexual violence, domestic violence is no exclusion that is corroborated by statistics. This year, domestic violence impacted 172% more children than last year. In our society, right until still there's this notion that if the child is not directly affected by violence, then their rights are not violated. That's wrong. In most cases, domestic violence acts are committed by persons who were themselves subjected to domestic violence in their tomb or were witnesses to such action from their children, from their parents. And then they later, in adult age, they copy these models of behavior. Children who were witnesses of domestic violence can be aggressive or, on the contrary, being apathetic to the surrounding world and later have many problems when building their family relations. So now it's time to strengthen our efforts in preventing and countering this phenomenon. In order to protect children witnesses in the national law, we're now operating with the notion of witness child and the definition that it's a child who has become a witness of domestic violence is automatically recognized as a victim of such act. And so the law does distinguish this category and attaches all the rights of the victim. And only it's our job to provide to the child this opportunity to use these rights and guarantees. For example, if it's psychological, economic violence, the person who commits this violence is liable on administrative offense. But it's important when we file a citation or protocol, we should put the basic data of the victim child as a person who's a victim of domestic violence. So what does it give us? If it's several victims, then the punishment will be more severe. Plus, this official complaint will be considered by judges as more grounds for restrictive indictment, restrictive indictment. So when it's about sexual violence committed against child, then we're talking about criminal liability. So in this case, the child receives the status of procedural status of victim. So these exclusive cases when in criminal proceedings, the child is a victim. When the child is witness of domestic violence, or then the witness child is official granted. But even if it's a witness, there are a number of rights that the child can implement or not.
Правничу допомогу. Це право на отримання.
So they're eligible to rights of social services, medical service, psychological support, compensation, reimbursement for. So the status of eyewitness and the witness of a crime. So crime committed in the presence of a child is a circumstance that makes the crime even more grave. And now we need to establish that fact and that will make the responsibility for the perpetrator more severe. And as initiated by the General Prosecution Office, we have updated the functions of the Register of Pre-Court Investigations, and we've added some attributes and parameters specifically for children witnesses, eyewitnesses of domestic violence, that we shall provide more statistical data of children that are affected by this type of violence. Also, I would like to scope the challenges that require legislative effort. So I think we need to expand the list of restricting actions that can be applied against a person who committed criminal offense in the presence of a child. Right now, as part of the criminal proceedings, only restriction of the rights to talk can be applied to such people. And also how criminal proceedings with the participation of children should be conducted, especially if it's in the interest of children who suffer from gender-based violence, domestic violence, sexual violence. So maintaining the interest of the best interest of children is highly important during such proceedings. Plus, there is the need to streamline a procedure of children interrogation, children witness interrogation with the best practices in mind. And understanding that legislation needs time, but children are suffering here and now, and they need our support right here and this time. So the Office of General Prosecutor has initiated to implement in 6 regions of Ukraine a pilot project which implements the child-friendly judiciary standards. The main objective of this pilot project is to provide the best interest of children who are now in legal procedure on all stages of criminal proceedings. In particular, this pilot project outlines the mechanism of interagency cooperation, a specialized training for all the parties who are contacting with the child as part of criminal proceedings, and facilitates the right of a child to be heard and to express their opinion, also their right for social assistance, legal support, and psychological rehabilitation, interrogating children with no undue delays in a space adapted and safe for children.
Also, this project includes the stability of the participants of the process and some other standards in order to provide the best conditions for the child. We cannot talk about drastic changes to the whole system as a result of this pilot, but I can say that this pilot brings positive shift. For example, the criminal proceedings where children are victims, so only juvenile investigators are engaged, psychologists are engaged, these are not just regular psychologists, but those who had gone specialized trainings. Now, more and more often, police officers and investigators, they use green rooms, friendly spaces, barnahus, and they more and more often use the Article 225 of the Criminal Code. They more often use videos for psychological analysis, and it all decreases the negative impact on a child and minimizes the risks of re-traumatizing the child. And to sum up, I would like to state that only by working together of all agencies and institutions involved, we can overcome the challenges and build the justice system which will keep child interest in the center of its attention. Thank you very much, Ms. Oksana, for this very important experience and for the approaches that your office uses. And we can feel that there are some changes in regions as well already. You already mentioned this positive approach about interviews for children, following international standards for these interviews. And I would like to highlight as well that because Prosecutor General has certain position, then something is done. And it is true that only because there are certain positions of the Office of Prosecutor General, all these standards that you mentioned are followed. So you are forcing to change these practices as your organization has a will. So because we've changed some approach thanks to engaging different parties in the system. So we could see some positive approaches and some positive changes. And moving forward towards interviews and new approaches and the input into some legislative initiatives and new policies, I would like to give the floor to Yaroslav Banchuk, the Deputy Minister of Justice, and also he is the head of Coordination Council on Children, and it's a very important platform. And I know that we already have some positive approach and positive models, which are not easy to implement, but thanks to coordinated efforts of different professionals, we start to use these approaches in practice. And I hope that in the nearest future we'll be able to share our Ukrainian experience with our international partners. So, Mr. Oleksandr. Good afternoon, everyone. Thank you very much for this introduction. And in this limited time, I will try to stick to 10 minutes. And I will try to share certain things, although I believe that many of the aspects I already mentioned, like Barnahus, psychologist, engaging psychologist. But I would like to emphasize 3 aspects. First, there's draft law on child-friendly justice. This draft law, why it's important? Because we wanted to implement the international standards on the level of legislation of our state. And Olga Kalashnik is sitting next to me, and so with the support of the experts of the Council of Europe who gave positive conclusion to this draft. But the movement is pretty slow. This draft has been in the parliament in 2021 for different reasons. But having seen that, we decided not to wait for the official change of legislation, but try to see and implement certain initiatives through pilot projects. And based on these pilot projects, to have strong arguments for legislators and to have arguments for ourselves, for international partners, and what works and what doesn't work in our context. So then second aspect, that's of course expanding the network of Barnahus. What is the essence of this network? That in the region, local authorities, they create a center where we can implement this child-centered approach. So the literal translation of Barnahus, that's a house for a child. It's taken from Scandinavian language, and So the essence is, if we have a child victim or witness in criminal proceeding, usually it is criminal proceeding around violence, then all institutions, they need to work with this child in one place. They need to do all the necessary procedural steps, provide medical assistance, psychological support, and sometimes it's not only the child, but usually it's a mother as well, who became either a victim or witness. And in some regions, these centers are built in the way that they can provide temporary shelter for these families. And in my opinion, it's not just theoretical, or it's not just law on paper, but through the activity of these centers, we are exercising this principle of child-centered approach. We have 8 centers like this in regions, and it's very important that it is opened and supported by local authorities. This regional military administrations, also district level, and city level. So this way we had 8. Kyiv, Chernihiv region, Vinnytsia region, Zhytomyr region, Kropyvnytskyi, Ternopil region, and recently opened in Odessa. So that's where we can find these pilot centers. And it's very important to realize that these centers are created so that the necessary institutions, police, prosecutor's office, court, can work in this place all the necessary proceedings. If we talk about statistics, in these regions, in these centers, are basically 7 which are actively functioning. Maybe we cannot talk about a big number, but 165 interviews. And the majority of these interviews are according to this Article 225 with video recording for not additional interviews, and so we can use video recording in further investigation. And about from 100 to 150 other services. For example, some medical checkup, psychological checkup, psychological support, medical assistance. So these services are provided in the centers, and the facilities of the centers allow us to do so. And I understand that I see uniforms of the National Police, but I'm sure that we have representatives of courts and prosecution at this event. So then I encourage all of you to use this opportunity. Please use them as widely as possible and exercise these best practices in real life. And according to our memorandum of cooperation of all of the institutions that I mentioned before, the Prosecutor's Office, the Ministry of Social Policy, and others, we are planning to open centers like this in more regions. And we hope that if local authorities are supporting the centers, it can provide sustainability of funding. If they found funding for opening the center, hiring personnel, it means that they can allocate money from their budget to support it as well. And the third aspect is registry of psychologists. You know that in our criminal code, it was stated that it's necessary to engage psychologists during the interview and other proceedings. But the question was always like where to find this psychologist, and that was the biggest issue for all the parties involved. And so based on this general provision in Criminal Procedural Code, we decided to create a registry of psychologists and pilot this registry. So it was created by Coordination Center on Providing Legal Assistance. This is the center under Ministry of Justice. We've selected 113 psychologists in 8 regions. They are not the same regions where we have Barnahus. So if there is Barnahus, then interviews should be conducted there, but in other regions, psychologists should be engaged. But we hope that we'll extend this registry to the whole country, and we'll have enough of these professionals. So 8 regions: Odessa, Ivano-Frankivsk, Lviv, Zhytomyr, Chernihiv regions, and Kyiv region, if I remember correctly. So the registry was launched in October. It was the work the Ministry of Justice, Ministry of Internal Affairs, and Prosecutor General. So if there is a need to engage a psychologist, they can come to this Center of Legal Assistance. And these centers can provide lawyers, but through this pilot project, we also take an obligation to provide a psychologist who lives in this area and who can provide psychological assistance in these 8 pilot regions. So the main task of the prosecutors and investigators just to come to us, and we take an obligation to provide psychologists without delays. And over the past 2 months, what I can see, we had 380 requests. They were all met, meaning that a psychologist was provided. Of course, as Criminal Procedural Code describes victims and but suspects as well. So we had 40 victims, 100 witnesses, and also we provide psychologists for suspects. And but there's a different discussion. But we provide psychologists as well for this category of children. And we hope that we can provide these services in the whole country. But after the pilot, we want to see the gaps. But at this point, we believe that this experience is positive and successful. So I encourage the participants from the police, courts, and prosecution use this opportunity in the best interest of children. Thank you for your attention. Thank you very much, Mr. Oleksandr. Yes, we've had a lot of challenges and active discussions. Different institutions were engaged in launching these projects. There were concerns about that as we don't have relevant legislation, it might not work, but the project had to be launched based on the legislation that we have in the country, based on international standards, international experience. So through discussion, we came to practice. We had some negative responses to using this model, and we had concerns, but we went through this initial stage, and it's good to see that these new institutions, we hope that they will become the part of our practice and they will be effective. And support of our international partners was very important to achieve these results. They trained us, they supported us, they provided trainings for psychologists, for people involved in Barnahu's model. They provide us materials, analysis, and for this reason, I would like to give the floor to Olga Kalashnik, the head of the project of the Council of Europe, protecting the rights of children during the war and post-war period in Ukraine, who will tell us about different steps and events organized by the Council of Europe, which will allow us to implement all these projects on the national level and to do everything in the interest of children. Greetings, dear participants, dear partners, and I would like to thank the organizers of this event, especially URFEM, for inviting me. And as previous speakers mentioned, Ukraine over the past decade has gone through important stages on protecting rights of children. But still, we face certain challenges. And these are challenges around following international and European obligations on to exercise the rights of children fully. Sexual violence is not stopped. And since the full-scale invasion, the scale of this violence is increasing. Children in occupied territories, IDP children, war migrants, children who are who live without their families, they become victims of sexual violence and exploitation. And so our project works with violence, sexual violence against children, which caused by different factors, ineffective system of protecting children overall, and also gaps in the system of justice, which is not always child-friendly. And for that reason, it is very important to have the support of the government, and that's what our project is about. Since 2012, Ukraine is a part on the Convention on Protecting Children from Sexual Violence and Sexual Exploitation, Lanzarote Convention, which is a comprehensive document which protects children from violence and talks about bringing perpetrators to justice. Also, the Council of Europe developed principles and standards on children-friendly justice, and you can find these principles in guidelines, which was approved by the Cabinet of Ministers of Council of Europe in 2010. And following the recommendations of Lanzarote Committee, Ukraine has been aligning Ukrainian legislation to the convention. In 2021, certain laws were amended in order to be aligned with Lanzarote Convention, and it indicates progress, and which is supported by the Council of Europe. But at the same time, there are some difficulties and challenges, especially if we talk about procedures and practices on implementing these new norms on Lanzarote Convention in practice. The biggest number of challenges are about the rights of children who become victims of sexual violence and exploitation on the internet, and in general protecting children's rights in cyberspace. So at this moment, 6 different professional systems are responsible for protecting children from sexual violence: education, healthcare, prosecution, courts, and it requires a high level of coordination. So at the phase 1 of our project, we had the report on protecting children from sexual exploitation, sexual violence, and implementing the model Barnahus was a part of this phase. So there are, the principle of Barnahus are part of these guidelines. And Lanzarote Committee recognizes Barnahus as the best practice for child-friendly interdisciplinary response to violence. So we truly support Ukrainian government, Ministry of Justice, on developing these centers in Ukraine. And in this context, in order to have successful interagency coordination, we support the initiative of Prosecutor General Office on implementing pilot project on implementing international standards into practice, which includes cooperating on the necessary institutions. This project is introduced for improving the pre-trial proceedings, effective implementation of international European standards on protecting children's rights. So our project supports training for interagency teams in 6 pilot regions of Ukraine. This team consists of police, prosecution, child services, probation, and lawyers. And the goal of these trainings is to develop child-centered approach and effective algorithm of cooperation of these different agencies in order to implement international standards into the activity. And during these 4-day trainings, participants can work on specific cases and develop these algorithms, engaging all necessary parties on every stage of pre-trial, trial, and the final stage when the child has contact with the justice system. Last year, our experts developed guidelines and the methods of documenting the violating of children's rights. And the purpose of these guidelines is to provide support to law enforcement, prosecution, and courts, and provide them tools how to document violating children's rights from sexual violence during the war. So this is educational material for all these institutions involved in pre-trial and trial procedures. Since 2020, this project has been supported by Ombudsperson on organizing monitoring on children's rights. Experts develop methodological recommendation on protecting children from violence, and in this manual you can find the tools which can be used for this monitoring. Our project also supports initiatives on the Ministry of Justice through providing analysis of legislative acts. And now we are at the final stage of finishing comprehensive research on child-friendly justice of Ukraine, and we hope that the recommendations of this research will be the base for the new national strategy on children-centered justice. And there is the educational platform Help. There is a course of children-friendly justice. So our project supported trainings using this platform for juvenile prosecutors and the national police. I would like to highlight that this course is open source. You can use this platform, register, and receive the knowledge you need. So the topic of this conference is justice, so I focused on the initiatives of our project which are centered around justice. Of course, we work on different initiatives which we support, and they are about prevention, psychological support of children who become victims of violence.
Thank you, Olga. And thank you, the project, for practical tools, because both principles of Council of Europe about child-friendly judiciary and different practitioners. We can see references to such rulings we can see in the court rulings as soft justice. So practical tools can be found there, all translated in Ukrainian. So we'd like to pass the floor to the next speaker, since there are a lot of experts working in pre-trial investigation, and then later when the case gets into the court. In the previous panels and discussions, participants were already referring to pre-court practice, to different court approaches, and thanks to this court experience, if there is a legislative gap, there's still court experience, and courts can respond quicker than the legislators to certain problems existing, and become certain tool of resolving this problem. Next speaker is Vasyl, judge of Kiev Court Dniprovsky. She's a speaker and teacher of National School of Judges of Ukraine. So you'll tell us about the approaches in courts. You represent the court where the judges see the problems live and working directly with those people. So this experience is very important. Hello, and we're trying to do everything possible so that there will be real indictments. Unfortunately, PR service still has a lot to work on compared to prosecution. And, you know, I caught myself thinking, for the first time, I can say, you know, not everything's so bad. So previously, speakers mostly focused on challenges and problems. It would seem like nothing works. But when we talk about children affected by GBV and domestic violence, indeed, in practical life, we as judges, we feel that like all these new things that the colleagues were talking about, they start working. I still remember times when there was just one guideline printed by Pavlo Parkhomenko, who has a lot of guidelines on child-friendly justice, and it was the only one book that the judges were reading. If you understand that for the third or fourth time there will be the interrogation for the same child, and it's traumatic, and we should not do that. So we realized that there is a gap in the legislation. Now, I can tell you from my district court, because I see that both investigators and prosecutors, they know about the how to properly interrogate children in Barnahus, how investigative judges should interview these people, etc. So in some part, it is a duplication. So in our, I knew what that would motivate, so that there's no need for repeated interrogation. So the prosecutors corroborate what they judges say. So for instance, there was a child interrogated by investigative judge. Now they, with the mother, they are abroad as refugees, but that doesn't prevent the case from being processed further. It's great that we have now register of psychologists, because in our experience, not all psychologists can actually help interrogate or interview a child who suffered from sexual violence, because that's very specific. You know, the judges go through trainings right now in the National School of Judges and using help platform. To go through training and read it a theory is one thing. When you take this case as a judge, understanding that there's a real child comes to you, and you understand the issues you have to be aware of to form the ruling, I'd say you need to allocate time for that and prepare, not only selecting proper questions, reading a legal framework and recommendations, but also be prepared morally. And, you know, if it's happening in pre-court investigation in another room, or so the judges try to provide that and interrogate these children according to the rules of child-friendly spaces. So when the relatives of the child have no interest for the, and they don't attend court hearings, they don't have any active position on the case, and in that case we are in a situation where the judges have to decide somehow, because the victims are not represented in the proceedings, and here the prosecutors have had to be more active, not only representing the prosecution, but see that the legal representatives use their opportunities to the full and fulfill their duty. As for training for prosecutors and judges and investigators, indeed they go through these trainings, and when they receive a new case, I see that prosecutors and investigators are aware of these issues, and I'm happy about that. The only thing that if these prosecutors leave their job or are promoted, then there's a gap. And it's great when there's someone to fill this gap, not a prosecutor as a punishment. You know, you're going to be appointed as juvenile prosecutor as a punishment, but actually a person who is professional and is ready to learn. Then the judges really see high quality work. Also, there is an issue of cooperating and understanding social services. What kind of assistance they can provide. But here it's more about administrative infringements, where children affected by domestic violence. And maybe it's gonna useful to be for you. We conduct coordination meetings sometimes. It may seem that it's something formal, but actually we invite the police and the judges there. I'm there as a judge. Free secondary legal assistance comes there, prosecution comes there, and we concentrate questions that emerge when we deal with administrative infringements. And there's an opportunity to talk to the stakeholders there and to clarify these issues so that we don't go through lengthy exchanges, which the court has no time for. So I know there are people from our precinct here. We have streamlined the work with law enforcement. They can file some proposals or criticisms regarding the judges or proceedings, and I can communicate with them. I can find some of the questions from them that judges may have. So this kind of communication, we have it, and the prosecution is working there, and we can quickly resolve these issues like that. And also recommend, if there is no good understanding, I know the police officers often criticize that they don't know how these protocols are reviewed by judges like this, why they are dismissing that. So we have quite well communication through speaker judges. In every court, there is a speaker judges for them whom it's not a punishment. They understand how important it is to communicate properly with different agencies. So you can talk to them. We had great cooperation with civil society organizations who provide services to victims of domestic violence, because courts are the place where people come with problems to, and they ask from us, from judges, what do we do next? What do they do next? Because the question of fines, arrests, it's not resolving this situation. It's only just one first step. And further, when we have leaflets, posters, and we know all the information where to file, where to direct these victims, we know we have all the booklets, the leaflets, to give them to because the scores of people who were affected by domestic violence is big. So children, we have tens of protocols for the same person, and children are recognized as victims of domestic violence. But still, me as a judge, I have a question. Has the Child Protection Service been informed? Does anyone know that there's this situation where 5 underage children and parents are drinking, and somehow the services are not involved? So we tell them, we show these leaflets and letters how to respond, because just recently, a month ago maybe, when the case on administrative infringement was, the perpetrator and the children were there. My colleague, right in the courtroom, hospitalized the child to the hospital. The child was in such a terrible state that even the doctors and judges were appalled. The child was going to school, and the police officers who came to location several times, and only one judge basically hospitalized this child in a critical state. And it was just it was a rare occasion where both perpetrator and the child showed up, because many times when I subpoena people to the court, they don't come. So, and I just want to know what's the situation in that family when there are 5 underage children and dysfunctional parents. So we need to communicate more to them, and we were very thankful. We would be very thankful if district courts would receive that plan of action with the Supreme Court and the roadmap, because we know that the cases of administrative infringement don't reach Supreme Court. And so 97% of them remain with the first instance court, and even only singular cases reach the Court of Appeal. So I think the courts of higher instance would it would serve them well to read this roadmap. So I would advocate more communication, looking for good things together, finding new ways to interact, because children are our future, and we have to make it, even in these conditions, the best that we can. Thank you, Vera, for demonstrating that the courts are not shut behind the walls, because people often perceive the court as some sort of institution that is not ready for cooperation. And you demonstrated this multidisciplinary approach, which is a very important element of child-friendly justice. I know that the Council of Europe is working towards that, and in many events where different experts go through training, they always ask why there's no judges, where are the judges? So we hope that in the future there will be discussions around training judges, because there are both positive and negative examples. There are some courts that are too close, because it's not an infringement on the independence of courts. When there's communication, there are principles, approaches. I think it's, on the contrary, it's a great element. It's a benefit for both practitioners and working towards the best interest of the child. I'd like to pass the floor to the next speaker, because we've listened to some examples from international partners, from Council of Europe, who have an extensive experience and assistance, and just as well other international partners, in particular UNICEF, who are providing serious assistance in different spheres. They help us shape the policies, they do trainings, they spread analytical materials, so it's a serious practical assistance. So the next, I would like to give the floor to Zaman Ali Hassan, who is the specialist in UNICEF in protecting children's rights. So we would like to hear your experience. What actions are done by UNICEF in protecting children's rights? The positive things that help us. Thank you.
Very much. I'm very sorry I'll be speaking in English today. Thank you for having me, and I'm very honored to be here, also to be part of the panel today. I was also very happy to hear that we are all speaking on the same approaches, on the same guidelines. This means actions and activity implementation can be much faster for children in the future, and this is very important. Also, I'm happy to hear the work on the Bornahus has very much advanced, and we're very happy as UNICEF to have been part of this type of work here in Ukraine, and we've been very happy also to take part into a lot of the child-friendly interviewing modules that have been also created this year. And yeah, we're looking forward also to advance all together, united on this work. There has been a lot of things that have already been said, so I'm not going to repeat, but maybe just a few things to highlight that have not been mentioned enough, I would say. A few things to say that we all say that women and children, whether they're boys or girls, are always, in most of the cases, the victims of gender-based violence, whether it's sexual abuse or domestic violence. So it's very important that we continue to provide this focus specifically on them. The other thing is we want to also recognize that reporting gender-based violence is not as much as we always expected. So this is something that is always underreported. And the cases that goes to prosecution is way much less than what is prevalent usually around countries. And this is also gives us a bit that usually the cases that end up in receiving some sort of a justice are the cases who had very brutal, I would say, violence being committed to them, and systematic one over the years that have made it much easier to document such incidents that we are able to take them to prosecution or to be prosecuted. And this is always a sad approach, and this is why we always need to strengthen our documentation. We need to build the capacities of our police officers in order to better document these cases when women and children call and seek help. The other thing that I also want to highlight is we spoke a lot about recognizing children as victims and not just as witnesses when it comes to domestic violence. And also, I think it's also important that we recognize that children require special protection, special assistance, and special services that is very much linked to their age, to their experience, and to their maturity level when we are providing, whether it is interviewing them for what they witnesses, or whether it is providing them with the support. The other thing I just want to highlight is around interviewing children who are witnesses and victims of gender-based violence or domestic violence. And it is very important that we believe children and we believe them when they speak. And it's not a word against word method when we do these interviews, but rather support them in processing their own feelings and what happened to them. Another thing that I would like to highlight is around that when we look at the process of supporting survivors of domestic violence, and whether they're women and children in courts or when we're interviewing and so on, it's also around our role in preventing family separation. And in many instances, we find ourselves removing children from their mothers. And this is quite something that does not always fit in the child's best interest. So there's a very big role that we can play in order to make sure that children remain with family members that can protect them, that can keep them safe, and then can allow them to live a happier life. And this should be always at the back in our heads, that supporting children to remain with family members, with caregivers, is a very important aspect as we continue to help them when they're seeking justice. And maybe the last thing I would say is that for survivors of specifically domestic violence and their children, being part of prosecuting their cases and seeking justice is a very big component of their healing process. And this is where the government, this is where authorities are validating their own experiences. They're validating what happened to them was not right, what happened to them was not correct, and it is really a big component of how they can continue to heal and seek support and give recognitions to themselves that they have the right for a better life, for a better partner in life, and for their children to have more opportunities and to seek more what they deserve in terms of safety and happiness. And I think this is also something we need to always remember, that this is also part of a healing process for them. I will stop here and thank you very much.
Дякуємо вам за те.
Thank you for this experience and the assistance and the actions that you do when you work with different institutions. And thank you for the materials that you provide to them. I would also want to thank all the participants who, for their multifaceted experience that they shared. And we still have some minutes till the next panel discussion. I would like to invite the participants, maybe you have questions. I see a lot of hands. Since we are pursuing here a practical discussion, then please, I've seen the first hand was raised over there. Let's see if the microphone is available. Greetings, I'm Olena Chernova. I represent the Coordination Center supporting the victims and witnesses. We have had not many questions today, so I would like to use that right for a question. Maybe it's to the old speakers. So it's about the qualification of psychologists and the before-mentioned register that was discussed earlier. But in order to ask this question, let me give a little background. You probably seen Just Talk show with Larissa Denisenko recently, interview with Arkady Bushenko, judge of Supreme Court. And they were exactly discussing a ruling of Supreme Court, January 17, 2023, which revokes the previous decision of the first and second instance court, where the victim of sexual violence was a child who, at the time of the crime, was 2 or 3 years old, and the perpetrator was the father of that child. The main evidence in that case was the testimony received in an interrogation of that child. So the decision was revoked because the interrogation or interview was done by psychologists so unprofessionally that it was basically the main ground for revoking that decision. So, explaining this background, maybe the question to Oleksandr regarding this register. Number 12, point number 12, of child-friendly justice means that the people who work with children or for the children, and I mean psychologists, including psychologists, they have to go through certain checks, certain vetting, or background vetting as to how professional are they, how well equipped they are to work with children. So my question is that, so the psychologists who are included into this register, how do you vet them, or if ever? So how do they have some practical qualifications? They have some experience or background or some psychologist education or a certificate? Because the psychologists who are in the register, they will be later engaged in investigating war crimes. There are a lot of children victims from social violence. Are these psychologists who go through some vetting and control, and what are the requirements of the psychologists at the moment? So thank you. Thank you for the question. Oleksandr, please. So my question, the people from Prosecutor General could answer, but then, you know, the essence of this register is that if we didn't implement this pilot, there was only one position of criminal code that the psychologist should be there, and that's the. And your task is where do you find this prosecutor? So the register exists so that in every area, the investigator and prosecutor would understand that if it's a child participating in criminal proceedings, that you have to employ a psychologist. And so they refer to free legal assistance. And we had this selection procedure to this register to basically provide certain quality. I cannot tell you at the moment because I need to see this. You know, they had to have specific experience, specific background working with children. What's also important, they have to, there has to be some quality assurance how these services of psychologists are delivered. So that's the foundation. So basically, in some ways, we copy the system that we have for free legal assistance, where we employ lawyers. So in criminal proceedings and the same model with psychologists. So not every lawyer or attorney, if we have 70,000 attorneys in the system, we have 5,000 that are in the system, 30,000 each year have agreements signed. So there's some sort of quality assurance. And just as well, there's a system we plan with psychologists. So it's the only thing is that it's a pilot project. Then this pilot project is supposed to cover the entire territory, and when we see the results of this model, maybe we'll try and using the budget money to pay for the services to psychologists. And then we need to introduce some changes in the law. So now we are in the pilot this model. And I hope that it's going to be a lot of help to judiciary. So I understand that the only doubt for you is experience and quality assurance of these people. Let me assure you, we do this vetting. That's one thing. And secondly, if we don't pilot this, it's just going to stay like that in the regions where there is no project. And then it's your duty going to be where to find that psychologist so that we formally stick to this requirement. So piloting this, that is the answer of this model, so that it doesn't happen that because of bad quality of the service, all the objectives, all the results are nullified, because the Supreme Court may rule that it's low quality evidence and everything is dismissed. So to avoid this kind of situation, that's why we implement this project. Thank you.
So you wanted to add something, Ms. Saman, and then we have another hand. Yeah, please, over to you.
Yes, I just want to, from a very pure technical perspective, that it's not only about the vetting process, it also goes beyond that, because psychologists are humans. They will make mistakes. They will be impacted by burnout, of course, and so on. So this is where it's important that we ensure that there is a supervision of for psychologists and for these cases, so that cases are not only just reviewed by one person only, but there's a process to review this, and there is also supervision being provided to psychologists in order to provide feedback, capacity building, and strengthening the systems where these cases go by. And I think this is also a very important aspect that we should not miss. Thank you for this question.
Дякуємо.
Thank you very much, Ms. Oksana. I also wanted to add, I want to draw your attention to this case. Yes, it was not a positive experience, but it was experience. If psychologist who interviewed the child used the methodology of green room, and when psychologist then was interrogated in court, so this the base of this interview was hearsay, and the court stated the psychologist provided the statement as expert, but the psychologist needed to share the information which was found out as a process of working with a child. So it was not only about qualification and training of the psychologist, but it was also the procedure. Good afternoon. So I had the department on protecting children's rights and interest in Zaporizhia. I would like to draw your attention to our Zaporizhia region. Unfortunately, now we don't have any so-called green rooms because of temporary occupation. 70% of our territory, of our region is occupied, so green rooms are on occupied territories. At the same time, we have increase in domestic violence, sexual violence against children. Also, we have more than 250,000 of IDPs, 30 kilometers to the front line, which is another factor for increase in violence. So are you planning to open Barnahus model in our region? It is something of critical importance, and we try to organize it by cooperating with national police, civil society. It's critical for our region. Thank you. Barnahus is a popular question. Of course, maybe our colleagues from UNICEF can help. I already presented that the peculiarity of Barnahus model is that it has to be initiated by local authorities. This can be organized by the city, regional council, or regional military administration, because they need to initiate the launching, organizing the space, and then they need to hire people and keep funding and sustainable existence of this center. And then we can do that. All social services and law enforcement, they will use the centers. So the original initiative should come from the local level. We haven't receive this initiative on local level, so my recommendation is to address the relevant institutions so that they can initiate this issue, because I know the examples of Ternopil region. That was the active position of regional prosecution, was that they initiated the organizing this center, and this is how this very active center was created in the Ternopil region. We cannot impose from the capital. We need to see local initiative of the national police, court, prosecution, that they are ready to use this cooperation and to have this interagency team. Then with our partners and donors, we try to respond. So my recommendation, maybe our colleague from UNICEF can say something else, but because I know that we are planning to work with Sumy, which is also near the border with the enemy, and then Volyn and Poltava. So these three regions are in the pipeline. I don't know about Zaporizhia. I understand your difficulties and your concerns. But in Mykolaiv, we reopened the center. They are on the border with Kherson region, so we opened the center before full-scale invasion, and then in June this year we reopened Barnahus in Mykolaiv region, and we already see the results. So you need to address to your regional administration and authorities if they haven't initiated anything. We are ready to look into these requests. Maybe UNICEF, you can say more. So, Ms. Zaman?
Thank you very much for this. I couldn't add more because I believe you covered everything. The request has to come from local authorities for sure, and we'll definitely be happy to support, and maybe we can have a small chat now after.
І я ще доповню, оскільки розглядалось питання мобільних.
And we also discussed the issue of mobile Barnahus model. Maybe this model can be suitable for regions like this. So keep in touch and talk to our partners, because Chernihiv region, that's where we had some attempts, but we had some issues with premises. And so we need to look into the best approaches. So now we can thank all our speakers, all our participants for this useful information, for this experience. We see that we are not standing still. We are trying to do our best, putting the child into the center. And I hope that that's the direction we are going to take in the future. Thank you.